So Kat gave us another update when it comes to what's going on with Tony Buzbee. We're going to read through it here in a second. Tony Buzbee, the same day, filed another legal document. What does it say? They have a reply in support of their demurrer to Carter's first amended complaint. Kat says, California's litigation privilege is strong. We'll see what happens moving forward here. So let's actually get into this other response. Again, we've got Camille Vasquez representing the Buzbee law firm and Tony Buzbee against Jayz. What does she say? Here we go. In an introduction, Jayz, Sean Carter, continues to double down on the dishonest arguments asserted in his first amended claim and other papers in this action. But his opposition simply highlights the feeble nature of his claims, all of which lack substantive support and which rest on blatant mischaracterizations of the record. What is she talking about? Jayz introduces a slew of facts absent from the first amended complaint, all of which fail to offer any viable amendments that could rectify these deficiencies. The court should sustain the demurrer and dismiss this action with prejudice. So what's going on here? Camille says the demurrer should be sustained. Carter's claim for extortion is based on privileged conduct and fails as a matter of law. Carter's claim for extortion is premised on two demand letters requesting mediation. The letters are indisputably protected by the litigation privilege and as a matter of law do not constitute a wrongful threat. Basically saying Tony Buzbee saying that, hey, this is what we're looking for. It's covered. It's legal. He's allowed to send a demand letter. It's not extortion just because someone's saying, hey, here's what we're going to do moving forward. You want to take care of this now or you want to take care of it later? No problem there, is what Camille's saying. Further, Carter cannot escape that he paid no money in response to the demand letters. Consequently, Carter is forced to contort both the facts and the law to argue the claim should survive. It cannot. Litigation privilege applies as a matter of law. Carter's opposition argues that the privilege as an affirmative defense cannot operate without external evidence and therefore cannot be used to defeat a demurrer. All right, so they're going to get into more legalese here. We get it. She's saying Tony Buzbee was allowed to send the demand letters. You have no legal basis for defamation and extortion. The demand letters are core litigation conduct and no finding to the contrary can be sustained. In an attempt to save his claim, Carter mischaracterizes the court's tentative ruling on the anti-SLAPP motion to argue external evidence is necessary. True, the court stated that for the privilege to apply, Buzbee's parties need to have contemplated litigation seriously and in good faith. However, Carter completely ignores the court's determination that the defendants have made the requisite showing here. In so holding, the court cites both one, the demand letters themselves, which invited confidential mediation to resolve the dispute, or if not, in a filed action, and two, the fact that the suit was ultimately filed satisfied that requirement, which are facts Carter specifically alleges in the FAC. The face of the pleading itself conclusively establishes that the privilege applies. All right. So what else does she say about the demand letters? The demand letters do not amount to extortion. Here's where we might disagree. And I want to see the full demand letter. I don't know if we'll get to see that or not, but at some point, hopefully we will. Independent of privilege, Carter has not adequately pleaded extortion and cannot do so. Carter's opposition purports to list elements of the extortion claim, but misleadingly cites to the statute defining fear. Interesting. And then she cites the case here. We've got Monex Deposit Company versus Gilliam. Carter ignores the essential element of extortion, that the action must be induced by the wrongful use of force or fear. Okay, California Penal Code 518. Further, Carter's reliance on federal law also ignores that no California court has recognized the tort of attempted extortion, and every California court has required the alleged exchange of property to adequately plead extortion. Okay. Carter's opposition tactically acknowledges that sending demand letters in advance of litigation is not extortionate behavior, and that sometimes, or that something additional is needed. Carter's theory is that threatening criminal referral in a demand letter is per se extortion. This creates two problems for Carter. First, nothing in the demand letters threatens criminal referral. Second, the law does not support that theory. I want to see these demand letters. Are they in here as exhibits? As to the first point, Carter acknowledges the demand letters contain no threat of criminal referral, which is true. And Jayz came out himself and he said, hey, if what you're saying in this claim is true, file criminal charges. And to me, that was the first time anything criminal was brought up. We could be missing something here, but we'll keep moving and see what they said. The letters did not threaten to publicize unrelated matters related to Carter, do not contain promises to refrain from going to law enforcement, and do not specify a demand for a particular sum of money. Well, he said a substantial. What was the phrasing he used? I can't remember, but it was something to do with a substantial amount or something like that. Anyway, thus Carter invokes the external context of the letters, but even there, Carter cannot identify any actual threat of criminal referral without distorting his own factual allegations. For example, Mr. Buzbee's alleged statements that other celebrities participated in what he labeled as a criminal enterprise is not a threat to refer to cases to law enforcement authorities. Interesting. Similarly, Carter repeatedly characterizes the Buzbee parties threatening to refer perpetrators to the FBI. However, the actual allegation from the FAC is that Buzbee's party's clients were available to the authorities, specifically to the FBI, and that we welcome the FBI or an authority who wants to come to us. So basically, he didn't directly say that he would talk to the FBI or he would go to the FBI with when it comes to Jayz, but he kind of in a roundabout way made a, what did they call it the other day? A conditional threat. I don't know. We'll see how the judge sees this though. Availability for contact with authorities is decidedly not the same as the threat to press criminal charges against Carter. What do y'all think? Let me know what y'all think about that in the comments and in the chat. If you're involved with someone and you say, man, I'm worried about this going down, they say, hey, listen, I've got access to certain people. I've got access to the FBI, local police department. And if they want to come and talk to me, I might have to say something to them. I don't know. It's up to you. So again, I'm just letting you know. It sounds like a, what did they say? A thinly veiled threat to me. I'll leave it up to y'all. Moreover, in considering the surrounding context, it cannot be overlooked that the public statements were vaguely asserted on behalf of clients in the plural and against celebrities again in the plural. So it wasn't just directed at Jayz, is what she's saying. It is simply not reasonable to interpret these generalized statements as specific threats from Jane and John Doe against Carter. Carter's own allegations belie and such argument. As to the second point, the law does not support Carter's theory that anytime a demand letter includes an allegation of torturous conduct that is also criminal, it is extortionate. Accepting a rule would prescribe the sending of demand letters for any civil tort that is likewise a crime. Yeah. I mean, demand letters seem pretty standard. That's what she's saying here. Indeed, Carter's tepid proposal of a demand letter that stated the lawyer represented a client who claims that she was assaulted and is willing to forgo litigation if an appropriate settlement can be reached. Oh, an appropriate settlement. Here we go. runs afoul of his own made up rule because it implies that there could be criminal action and makes a demand for a settlement. Under Carter's false construction of the rule, it is impossible to imagine any demand letter in an assault case that would not constitute extortion. Basically, what she's saying here is anytime anybody who practices law sends a demand letter to someone when it comes to a civil case, under Jayz's rule, that would be considered extortion. And she's saying that's not the case. She might be right. Because if someone brings a false claim up against you and they say, hey, we want to have a meeting. We want to get, what was the phrase again? I always forget this. An appropriate settlement. You say, no, this isn't true. I'm not doing that. And they say, okay, we're going to move forward. That in itself is not extortion, is what Camille is arguing here. Y'all will have to let me know if you agree or not. Carter's extreme position leads him to the bizarre and patently insupportable assertion that this case is even worse than Flatley. I don't know who Flatley is. Yet in Flatley, the purported victim had allegedly created a sham record of a police report that would make her threats more ominous, while preventing the police from taking an action that might make the matter public, since any public report of the police action wouldn't necessarily spoil the scheme. The Flatley demand letter also specifically threatened, to disclose to the authorities violations of the U.S. Federal Immigration, IRS, SS, and Administration, U.S. state, local, Commonwealth of UK, or international laws, if payment was not made. Finally, the defendant lawyer explicitly threatened to see that the story would follow him wherever he or his groups perform and would ruin him. Dang. It is impossible to justify or support Carter's argument to the court that Buzbee's party's demand letter asking for mediation was extortionate at all, much less more extortionate than these actions. I don't know. I'm kind of agreeing with Camille here. It just seems like a standard practice. It sucks. But again, I said this yesterday. Don't hate the law abiders, hate the law. So if you don't like the way that civil cases are handled, you might have to do something about it, find a way to change it. But people can bring these claims against you. The lawyer is allowed to send you a demand letter saying, hey, let's try and figure out a settlement so we don't have to move forward with this. Just because they're asking for money on something that might not be true, according to the law, you're allowed to do that. Carter's extreme position likewise leads him to ignore that every case cited in both the Buzbee's party's Demurrer and in Carter's opposition and in the anti-slap briefing follows the rule that a demand letter only becomes extortionate when it makes threats that are unrelated to the underlying claims of the alleged victim. All right, so the claim itself isn't illegal. So we'll go through here more legalese. And then she says, finally, Carter incorrectly argues that payment of money is not required to state a claim, citing only Flatley. However, Flatley expressly limited its holdings to the first prong of section 425.16 and made no determination regarding the elements of civil extortion claim. Okay, so we're not going to get into that. The plaintiff's claim for extortion fails on the Demurrer. What else does he say? Carter fails to state a claim for defamation. We already went through that. And then she says the statements A through D are not of and concerning Carter as a matter of law. What else? She says statements E through F are in the context of ongoing litigation and are his opinion. Lastly, well, this isn't lastly, Carter fails to allege malice because he can't prove that because they just sent a demand letters. What she's saying, Carter fails to allege special damages. To the extent these statements are defamatory at all, which they are not, they require proof of special damages, meaning actual monetary loss. Yet Carter fails to allege anywhere in the FAC that he suffered any such loss. And she's saying loss as a result of the demand letters. Nor could he cure this defect throughout the amendment, as the only loss he has referenced to date concerns alleged damages suffered by Roc Nation, a non-party that was not defamed. Interesting. But if Jayz represents Roc Nation, that's an interesting point. Without an allegation of actual personal economic harm, Carter's claim is legally insufficient and must be dismissed. Dang, this thing might be dismissed. Camille makes a great point. Carter fails to state a claim for intentional infliction of emotional distress. That one I think is going to be hard for them to fight because he talked about the whole situation with him having to make a decision between either settling things with Tony Buzbee and Jane Doe or Tony Buzbee going out right before the premiere of Mufasa, his daughter's big event, and bringing this case forward, which ended up, as we know, happening. So the emotional distress part, I think I can see. The court should sustain the demurrer without leave to amend. And this was signed on March 19th by Camille M. Vasquez. Camille putting in work here. I mean, I could kind of see her point. I can see her point through a lot of this. The financial part, I think it's going to be harder to prove. The emotional distress, I can definitely see where Jayz has some emotional distress there, but we would have to actually look through the law and see how that would apply. Either way, y'all let me know what you think about this in the comments and in the chat.